Good morning, Supervisors, Chair. I'll sign after. I'm going to continue on with this notice that we put in.
And you are?
Chris Strong, Amador County. Thank you. Also foundational to our constitutional republic is that the process of voting must be free, fair, and accurate. The 2020 presidential election and all elections since then were touted by governments at all levels as free, fair, and even the most secure elections in history. Since 2020, little by little, the evidence has come out that these elections were not free, nor fair, nor secure. For example, every county registrar in every county in the country represented that voting machines were not connected to the internet. Since then, it has been universally admitted that the voting machines were connected to the internet either by cable or by Wi-Fi. While counties maintain a log of those who physically access the individual machines in person, there is no record of unauthorized access to the machines using Wi-Fi during non-business hours, nor while actually counting votes. Since before the November 2020 elections, registered voters in each county nationwide represented the voting machines that they could not be and were not hacked. Are you aware that in the federal district court in Georgia, there is a case named Curling et al. Versus Brad Raffensperger, with Brad Raffensperger as the Secretary of State for Georgia? Are you aware that during the trial in the above-named case, University of Michigan professor Dr. J. Alex Halderman was able to hack an electronic voting machine with only a ballpoint pen and a card and altered the vote totals in open court as the judge watched? Are you aware that the machines hacked by Dr. Halderman is the same type of voting machine used in this county? Georgia Secretary of State Brad Raffensperger has jointly met with the California Secretary of State Shirley Weber and registrars of voters from all California counties. And we want to know if our county participated in that. And they're willing to discuss exactly what was discussed in those meetings. Are there any memos and or emails that mention the meeting mentioned above? What was discussed? What was decided? If there were any decisions, any tasks assigned, or any plan of action? We'd like to have disclosed any memos and emails by this demand for information and without order of any court. Are you aware that in the federal and state laws there is something called racketeering, influenced corruption organizations, RICO? Are you aware that voters in this county generally, and me specifically, have been damaged by the collusion between Brad Raffensperger, California Secretary of State Weber, and one or more registrars of voters concerning what we know as a false narrative of the alleged integrity of the elections from November 2020 to present? Thank you.
Thank you. Is there any other members of the public like to address the board?
I'm Oral Custer, and I really appreciate the opportunity as a member of this team to present material prepared by the great new state of California. So I'm just going to share reading from the prepared material. We, the people of the great new California state, notice to all Californians declaration of the 11th constitutional default. The citizens of New California have decided to remedy the abuse of power by the government of California by exercising their right to form a new state, provided in the United States Constitution, Article 4, Sections 3 and 4. We are determined to live under a state government in the United States of America and under the Constitution of the United States. A selected governor who has never won an election to office without the help of a corrupt banana republic selection process, where the globalists, cartels, and the Chinese Communist Party, or CCP, pre-selected the outcome to illegally place him in office, has committed treason. A selected governor who openly defies Article 4, Section 4, and its three guarantees of a Republican form of government, keeping all Americans free from invasion and that of domestic violence, is committing treason. The 2018 midterm elections, 2021 recall election, and the 2022 midterm elections were all lost in one-to-one balloting, but with the help of a fraudulent electronic election system. An algorithm and the actions of the globalist cartels and the CCP, a dictator was installed to oversee their province of California. Now, with the help of the federal courts in the state of Georgia and their unwitting, corrupted Secretary of State, Brad Raffensperger, the evidence is clear for the world to see how the selected treasonous governor of the province of California and thousands of down-ballot, corrupt, selected officials turned the once great state of California into a Nazi communist totalitarian province. Thank you.
Good morning, Jeff Landauer from Pine Grove, California.
What was your
this is,
name again?
Jeff Landauer.
Okay, thank you, sir.
This is count 7, continuation of what Oral just read. In June of 2023, the Federal District Court for the Northern District of Georgia unsealed the so-called 96-page Halderman Report, security analysis of Georgia's ImageCast X ballot marketing devices. Georgia Secretary of State Brad Raffensperger had been hiding this report from the public for 2 years. University of Michigan professor of computer science and engineer J. Alex Halderman and security researcher and assistant professor at Auburn University Drew Stringall collaborated on the report, where they discovered many exploitable vulnerabilities in the Dominion voting system, ImageCast X system. J. Alex Halderman demonstrated in court how Dominion machines are hacked and their tabulations are easily altered to select any individual for any office. In the Georgia courtroom on January 19, 2024, J. Alex Halderman demonstrated in explicit detail to the court and to the world how easy it is to hack into the Dominion voting systems and alter votes. This is the first time in a court of law such a demonstration has taken place, which details in undeniable fashion how the vast electronic elections system can be altered and thus corrupted. Following an audit of the elections of 2018, 2021, and 2022, utilizing data provided by each California county and the Secretary of State office, it was obvious an algorithm was used to create weighted vote values in the Dominion and other vote tabulation devices by those who facilitated the election of the governor. The evidence in the Georgia federal court presented by J. Alex Halderman overwhelmingly supports the use of an algorithm to facilitate the corrupt election of the governor. The fraudulent election system does not function without the help and support of state and county employees who either knowingly or unwittingly have worked together to perpetuate the corrupt election system. It is also known that the Secretary of State of the state of Georgia, Brad Raffensperger, has visited Nevada and contacted numerous California county clerks and state officials to support their actions to continue a false narrative to the citizens of the new state of California and California state, that the election systems are all fine. We now know the Raffensperger and California County and state official narrative is a deliberate lie. And we have a copy to give to the board. Thank you.
Thank you. Is there any other members of the public like to address this board on any item? Well, seeing none, we have approval of the agenda, and I think, Chuck, you had an item you wanted to pull? Continue to a later date.
Pull, let's see.
6B?
It's- Yeah,
Okay, we're going to
Yeah,
go ahead
6B.
and pull.
6B, and we may bring that back at a later date. We may not need to.
I could pull item 6B, and we may bring it back to a later date with
Move
that.
approval of the agenda with that item pulled.
Second.
We have a motion by Forrester, second by Crew. All in favor?
Aye.
Aye. Any opposed? Carries unanimous. With that, we'll take item 6A, this discussion of possible action relative to the request by Gold Country.
Got the consent agenda too.
Oh, thank you. Consent agenda, motion approved.
So moved.
Second.
Motion by Crew, second by Axe. All in favor?
Aye.
Aye. Any opposed? Carries unanimous. Now we'll move down to item 6A. This is on the regular agenda, and this discussion, possible action relative to the request by Gold Country Campground located at 13026 Taboo Road, Pine Grove, for finding of public convenience or necessity for an alcohol license application currently before the Department of Alcoholic Beverage Control.
They've had a permit before, so I don't see any issues approving this. For
Yeah.
staff- For staff to write a letter in support.
The applicant was going to try to attend via Zoom, and we don't see him.
Yeah, no, I agree with Richard. I mean, we've had one previously. It's kind of almost more just housekeeping. And
Been trouble-free.
Anybody familiar with this? This Gold Country Campground, is that right next to, before Roaring Camp? Is that right?
It's
Yeah.
before Roaring
No.
Camp.
kind of on the left going
On the
in.
left as you're heading toward Roaring Camp.
Yeah, it's called, used to be called Pine Acres Resort and then Jelly Belly and,
It's actually right across from their office that they have on Taboo Road.
Yeah.
If you're familiar. And it's not too far from the old fire station.
yeah. Well, any members of the public like to comment on this issue? Seeing none, looking for a motion.
I'll make a motion then to provide it's a public convenience or necessity letter from the Amador County Board of Supervisors for Gold Country Campgrounds.
Second.
Motion by Axe, and we have a second by Brown. All in favor?
Aye.
Aye. Any opposed? Carries unanimous. Moving down to item 6C, this would be the minutes.
I have some minor things, and then right at the beginning, it says that lists Jeff Brown as the chair and Brian Onetto as the vice chair.
Didn't catch that.
Yeah, it should probably be Oneto and Crew, so.
And then I have some minor corrections beside that, so I move approval with those changes.
Second.
Okay, a motion by Forrester and a second by Axe. All in favor?
Aye.
Aye. Any opposed? Carries unanimous. Well, it looks like we're early for a public hearing, so I think at this point,
We have more closed session.
Yeah, we can go back into closed session.
Yeah. so we will go into closed session and come back out and resume the public meeting at 10:30. Thank you. Good morning. Call this meeting back to order. Board met in closed session. Item 1A, nothing to report. And item 2, the backstop settlement agreement was approved and direction was given on the other item. Claim 3A was denied. Claim 3B was denied. And 4A, which involves a tribe, Vice Chair Crew will give an update on that, as I have a conflict of interest on that.
Just update to staff.
Update given.
Update given.
Okay,
Yep.
thank you. With that, we're going to go ahead and go into our public hearings. They're scheduled for 10:30. Our first item is 7A. This is Surveying Department, public hearing and adoption of the resolution approving a certificate merge for David Mark, Alan McDonald, and Delane Lindsay McDonald. The properties involved in the said merger are adjusted compliance parcels 5 and 6 as shown in Book 65 of Maps and Plats of Amador County Records. With that,
Good
Keisha.
morning. Good morning. The customers are requesting a merger so that in the future they can perform a boundary line adjustment with parcel 7 on the same recorded map.
okay. Are there any questions from the board?
No?
Routine.
Okay. Well, looking for, actually, any members of the public like to address the board on this item?
Move to close the public hearing.
Second.
Second? Okay.
Okay, motion by Forrester, second by Brown. Close the public hearing. All in favor?
Aye.
Aye.
Move to adopt the resolution approving issuing the certificate of merger.
Second.
All in favor?
Aye.
Aye.
Aye. Any opposed? Nay. Also, in the previous, to close the public hearing, was there any nays? Seeing none, both motions pass unanimous. Okay, well, thank you. Moving on down to item 7B. Surveying Department, public hearing and adoption of the resolution approval for a public utility easement abandonment and certificate of merger for Russell and Amanda Arnold. The properties involved in the said merger are adjusted lots 1 and 2 of Rancho Del Monte subdivisions recorded in Book 4 of subdivision maps at page 58, and adjusted by boundary line adjustment shown in document 210-0009981 of Rex, Amador County. Okay, Tisha, this time, guess what?
Thank you. In this certificate of merger and utility easement abandonment request, the lots have been adjusted in the past, but this will adjust the lots so that they have enough room for building, and they're going to avoid an encroachment by having that additional space. The easement is only being abandoned between the two properties, not in the service area.
Okay. At this time, we'll open the public hearing. Any members of the public have any comments? Board, any questions?
Move to close the public hearing.
Second?
All in favor?
Aye.
Aye. Any opposed? Carries unanimous.
Move to approve the resolution issuing the certificate of merger and the resolution of approving the abandonment of a public utility easement.
Second?
So a motion by Forrester, second by Axe. All in favor?
Aye.
Aye.
Aye. You know what? We didn't have any members of the public like to comment. Seeing none. Any opposed? Carries unanimous. Oh, now we got item 7C. It's the appeal of the county's determination that the grading and encroachment permit applications to construct a public roadway for appellant's 281-unit residential project, Lake Comanche Village Unit 3B, are incomplete. The county deemed the application incomplete because the applicant failed to provide the information the county requested to evaluate environmental impacts and the California CEQA California Environmental Quality Act. The applicant contends the county cannot request information that is not specifically listed on the county's application checklist. So we'll have some discussion on this item. And at this time, I believe we'd like to hear from staff.
Open the public.
And we're going to open this public hearing.
Morning, Board.
Morning.
Morning.
Beatty with the Planning Department. I'll go through the basic timeline on this application. I'm sure council will have a lot to say about it. In May of last year, the appellant submitted applications for both grading and encroachment permits that were necessary to begin a review for the street construction on a subdivision that was recorded in 1973 prior to CEQA at Lake Comanche, Unit 3B of Lake Comanche Village. The county notified the appellant that the applications were incomplete and requested some additional information so they could review that application to see if additional environmental review was necessary. In June of last year, the appellant argued that the incomplete determination was improper because the county was only allowed to ask for information that's included on its published application checklist. The county has reiterated that could not deem the application complete without the additional information that it requested, and ultimately the appellant sued the county seeking to compel the applicant, deem the application complete. That decision was won by the county, and the appellant has since appealed that decision to the Court of Appeal. When any of the county departments are trying to look at an application to see if it needs additional environmental review, particularly when there's that potential, it's incumbent on us to collect the information that we need in order for us to make that determination. And if we find that it needs additional information to move on to a higher level of environmental review, we have to have that information in order to make that determination one way or the other. In this case, the information that was allowed to be collected by the Public Works Department wasn't provided to the Public Works Department. And we have a county code that says if you move more than 5,000 cubic yards of dirt, you have to go through a greater environmental review process. This project proposes to move more than 10 times that amount. The issue before the board is, did the county appropriately deem the application incomplete because it didn't have the information that it needed? That's basically what's before you today. If you have questions, I'll try to answer those. Thanks.
Nope, thank you, Chuck. Any questions from the board? At this time, would the appellant like to make their case?
Good morning, Supervisors. Brad Johnson on behalf of the appellant Old Golden Oaks, LLC.
Morning.
So I appreciate this, this opportunity to be in front of you today. The Judge Hermanson's decision, which I'll talk a little bit more about in detail in a few minutes, part of that decision said that we needed to exhaust our administrative remedies in front of the board before taking this issue back to him. So that's why we're here in front of you today, even though he seems to have rendered a summary decision. But that's why we're here, in case you're wondering why we're here at all. I'm happy to have an opportunity to discuss this project with you because I think there are some misunderstandings and misconceptions that staff are carrying forward, and I want to have an opportunity to clear that up with you. Like you've heard already this morning, this project was originally approved in 1970. The tentative map was approved in 1970. The final map was approved in 1973. So this subdivision, which is part of several other subdivisions that were approved around the same time, is 100% fully approved. And that's an important point, and I can't underscore that enough. It is an approved subdivision. We're not asking for permission to build houses. That's already been given. The second issue is, to put things in perspective, what we're asking for is a grading permit and an encroachment permit to finish grading roads that have already been rough graded, for which the county has already issued a previous grading permit for these same roads. So this isn't a new activity. We're not building new roads. These roads are already rough cut in. In fact, they've already been sufficiently cut in that they were already dedicated to the county and accepted by the county. That's the only reason that we have to get an encroachment permit in addition to a grading permit.
How many yards you say you're moving again?
Approximately 50,000 cubic yards is going to be a finished grade and pave.
That's a substantial amount of dirt.
300-acre subdivision with 281 units.
Yeah, that's a lot of yardage.
It is. So, 2 points to reiterate. One, this is an approved subdivision. Number two, we're asking for a grading permit and encroachment permit to finish work that's already been started. The county issued a grading permit for this project to do this work in 2010. The work wasn't able to be completed under that permit. That permit expired. The county didn't require a SEQA review for that permit. What's the difference now? We're just here to seek to continue to finish the work that's already been started.
Was SEQA even required back then?
In 2010?
No, previous back in the 70s.
So-
1970, 1973.
Yeah, so the tentative map and final map were approved before CEQA was effective. Now, that means that this project is grandfathered. The project itself is not subject to CEQA. It's already approved. Now, the way that the law works is if there are subsequent discretionary entitlements that are required for this approval, for the subdivision that were not part of the project that was approved in the 70s, those subsequent discretionary decisions can be subject to CEQA. But the scope of the CEQA analysis has to be related to the actual discretionary approval, not to the housing subdivision. And that is a critical point. I can't underscore that point enough. So we can't use CEQA for a grading permit to go back and evaluate the environmental impacts of the entire residential subdivision. That's not allowed. So what's happening now? Like I said, we're here trying to get a grading permit and encroachment permit approved to finish roads that have already been started. Now, it seems silly that this has become such an issue. And I understand that the county has talked at great length in its letters to us back and forth in front of the court, and you heard briefly this morning that the reason the county is asking for this additional information in relation to the permits has to do with CEQA. And that's only the tip of the iceberg in this story. The county has specific requirements for a grading plan application. You have those in a packet that I submitted to you. You've probably all seen them yourselves. It's a pretty simple 7-item checklist. The county also has a checklist for encroachment permits, and that checklist exists in County Code, section 12.10.140. Now, one of the line items in that code section says, among other things that need to be submitted to support an encroachment permit, other information as may be required by the director. And that's the problem here. See, the Permit Streamlining Act was adopted, and this is straight out of the Supreme Court's mouth here. The Permit Streamlining Act was adopted specifically to address these kinds of issues and to ensure that applicants are relieved from protracted and unjustified governmental delays in processing their permit applications. The reason the Permit Streamlining Act was adopted was because local governments were playing games with application requirements and using shifting application requirements to avoid having to process development applications. And that's why the Permit Streamlining Act was adopted in the first place. And it's also why in the Permit Streamlining Act, you'll see repeated the requirement that the agency can only determine whether an application is complete based on whether it contains, quote, those items actually required and specified on the lead agency's submittal requirement checklist. So we took this issue to Judge Hermanson. I've appeared in front of Judge Hermanson many times. He's an excellent judge. With all due respect, he is not a land use expert. That's not the area where he shines. His summary opinion on this case did not examine the actual textual requirements of the PSA. It rested on one thing, in the county statement that they needed to ask for additional information to satisfy their obligations under CEQA. There's two problems with that statement. The first is they don't need to try to push off deeming our applications complete in order to request information for CEQA. There's a specific provision in CEQA that makes this clear. And that provision says, accepting an application as complete does not limit the authority of the lead agency to require the applicant to submit additional information needed for environmental evaluation of the project. Requiring such additional information after the application is complete does not change the status of the application. That's CEQA Guidelines Section 15060, directly on point. Judge Hermanson didn't even talk about that provision, the most relevant provision to this question. So you're being told by staff that they have a right to exploit a loophole in county code, one that is directly in conflict with the Permit Streamlining Act, for the purpose of asking for additional information to make a CEQA determination on this grading permit application. It's not true. They do not need to do that. CEQA expressly says you can ask for additional information after deeming an application complete in order to comply with CEQA. The second problem with staff's representation to the board is that the items that they're asking for are not related to environmental review. Okay? Things like an on-site soils evaluation and conceptual wastewater treatment design. That's not a CEQA issue. A plan signed by the Amador Water Agency that shows the proposed locations of all water facilities, as well as the location and size of all water transmission and distribution facilities. Also, not a CEQA issue. A conditional will serve letter from AWA, which includes input from Jackson Valley Fire Protection, not a CEQA issue. I can continue on. These aren't CEQA-related requests. These are permit processing requests. So the story that you're being given by staff is not correct. It's not correct on the facts. It's not correct on the law. We have appealed Judge Hermanson's decision. Procedurally, we have to protect our rights. It's going to the third DCA. I'm confident that we'll get a correct decision out there because Judge Hermanson is not correct. Staff are not correct. So I want to bring the board to kind of look at this in a broader perspective. This is an approved project, as I've said. This is a silly waste of time and resources on both parts to argue about whether the applications for a grading permit and encroachment permit are complete. Why do we even care? We need the county to deem these applications complete so that the county then has an obligation to begin reviewing these applications. Then the county can make a determination about CEQA. That's the natural order of things. You see it in many projects that you've approved and reviewed. It's all the same. Application gets deemed complete. County then makes a CEQA determination. CEQA is either required or not required. Permit is processed to approval. That's the process. Right here, we're trying to reverse the process. Trying to do CEQA before we've even deemed the applications complete. That's not the way it works. There are a number of issues in this subdivision that I think are vexing to staff. And they are related to the fact that this subdivision was approved in the 1970s. It's not a modern subdivision. But the decision has already been made. This subdivision exists. It's approved. And if the county sets out on a path that denies my client the opportunity to develop that subdivision that is approved, that's a problematic path for the county, to say the least.
You know, I would think you have your entitlements as far as your zoning. That's been approved. The other question is going forward on the other items like your grading and encroachment. You're asking them to sign off on something when they don't have all the information.
So that's not true. So it's not a matter of zoning. This is a tentative map and a final map. That's not zoning. That is an approved right to build a subdivision.
But to get subdivisions, you have to have the correct zoning and their approvals, and those have been given. You have those.
Right, but again, this is more than zoning.
I understand that.
Yeah. So the question that we're here to decide is.
Grading
this-
encroachments,
Yes, and the county has all.
as you know.
Yes, and the county has all that they need to make a determination. They have every item on the county's grading permit application checklist, every single one.
So you're saying they have all the information where, what type of,
So if you look at the grading plans.
your wastewater and your water, where everything's going, and what type of water you're gonna be using, and where it's
So-
coming from, and,
If you look at the grading plan submittal checklist, which you must, every single item there has been submitted to the county. Every single one.
You feel our staff are, by your own statements, playing games here.
Yes.
Why not just comply and give the information, and then everybody can save money, and we can move forward?
Because it doesn't save us any money. It puts us through a process that is essentially a reevaluation of an approved subdivision. That's the problem. So staff are using this as an opportunity to try to make this a modern subdivision. And that ship has sailed. Now, will things be built to current code? Of course. But in terms of reconfiguring this subdivision in the same way that you might do so today, that's not an option. And that's what I mean by playing games with the approval requirements or the permit application requirements here. So you as a board need to look at the actual requirements of your own checklists here. One is your grading plan submittal checklist. So I'll just read them out. Entire legal lot included, drawn to scale. So that's a map requirement, a drawings requirement, completed. Topography on a map, completed and submitted. Location of any existing environmentally sensitive areas, completed and submitted. Existing surfacing, completed and submitted. Proposed finished grades, completed and submitted. Proposed erosion control plan, completed and submitted. Copy of easements or right-of-way agreements, if applicable. That's not applicable here. All things have been submitted. So you as the board are left with a decision on, if all those things have been submitted, why is staff not required to deem the application complete? Turning to the encroachment permit application. Name and address of the applicant, the owner or the other person responsible for the proposed encroachment, completed and submitted. Location of the encroachment, completed and submitted. Nature of the encroachment, completed and submitted. Estimated time to begin and complete the event, that's also completed and submitted. Site plan showing relation of encroachment to county road, completed and submitted. The only thing that hasn't been completed and submitted is other information as may be required by the director. And that other information is largely water related. Will serve letter, which by the way, Amador Water Agency already issued in 1986. Proposed locations of water facilities, signed by Amador, that's not a requirement of the grading permit application or the encroachment permit application. So, none of those items exist anywhere on the county's published checklist. The county's loophole provision saying we can request, in addition to these specified items, anything else that the director requires is in direct conflict with the Permit Streamlining Act. So, the request before the board is, let's stop wasting time and resources on this question, get past this permit completeness issue, and let's move forward to actually reviewing these applications in earnest. That's the wise thing to do here. It's the correct thing to do here. Thank you.
thank you. Any questions? Yep, and now we'll hear from defendant. Guess we'll call you that.
Yeah, if you'd like me to address some of those points, I can address some of the points that were raised here. First of all, the main issue that was resolved in the litigation has to do with this checklist issue. And the Permit Streamlining Act is really clear on this point, that agencies are confined to a checklist unless information is needed for CEQA. big exception, an exception you can run a truck through. And that's the exception that applies here. When CEQA applies, as it does here, and information is needed for CEQA, an agency is free to ask for it. That's the way it's done up and down the state. Every agency does that, common practice. The court ruled correctly in the county's favor on that point. The applicant says there's an approved project. Now, the map, yes, is approved. One of the most important parts about the map are the improvements that are required. And the most important improvements that are referenced in the map are water, sewer, and roads. And there's a lot of decisions that need to be made with respect to these improvements. And there's a wide playing field on how these improvements can be accomplished. For example, water is the biggest improvement. We provided a contract there. The developer is under contract with AWA to provide a plan for water and then to construct those facilities. Well, there are virtually 1 million ways that just water can go forward, which is precisely why you need to analyze these issues under CEQA. And AWA is going to need to rely on this EIR as well. So that's specifically tied to this approval, to this map approval. So it's not a done deal by any stretch. There's a lot that still needs to get analyzed. One of the fundamental rules in CEQA is that you cannot piecemeal a project. You can't analyze a little part here, and then move on to this little part and this part, because every little part will be a minor impact. CEQA says, no, you can't do that. You got to take the entire project up front and you've got to analyze it, because that's the only way you're going to capture significant impacts. Now, the most important thing the county is going to do right when it receives the environmental information and deems the application complete is determine initially what environmental route do we need to take, and the county only has 30 days to do that. The fundamental issue for CEQA is that you have to analyze a stable project. At this point, we don't even know what the project is. And again, let's just stick to water. We have no idea where these facilities are going. We have no idea how many wells, where well purification plants are going, how these wells, how the water is going to get run to these homes. That's just water. The other issues are at play as well. Now, and the county requires the infrastructure in the road, so we need to get these things figured out regardless. But more importantly, we can't be violating the rule against piecemealing. Got to have the EIR up front for the first discretionary approval going forward. Every other agency is going to need to rely on this. AWA, the state agencies, and any other agencies that are going to be providing approvals for this project. I think that addresses some of the main points. If there are any questions, I'm here. I can address it right now if you want.
Is the statement that was made by the proponent's attorney that the PSR is overriding and you cannot have a statement in there that says, and any other conditions that might be asked for? Can you address that a little further?
Yeah, sure. So I did a review of other agencies in the state, and it seems that approximately half of the agencies have that general statement and any other information that we need. We have that agency, or we have that provision. It's really not that important. As I see it, it's more if you need the information for CEQA. The bigger point here is whether CEQA is triggered. If CEQA is triggered, it doesn't matter how that checklist is confined. An agency is allowed to ask for additional information. So whether there's a separate provision in the checklist itself that says, and we can require additional information, That's fine, but that's a separate issue. Even if we didn't have that provision in the checklist, because this project is subject to CEQA, the county's entitled to ask for additional information prior to deeming it complete.
Nick, also in the county, isn't anything over 5,000 yards trigger a secret requirement from the county?
Yeah, that doesn't, the issue with CEQA is if your project is going to change the environment, and this one is clearly going to cause a change in the environment, so it triggers CEQA. But there are also definitely, like you're saying, yes, provisions within the code that say, hey, even if there was any doubt whether CEQA applies, it applies, whether if you're grading in excess of 5,000 cubic yards. Here we're grading in excess of 58,000 cubic yards.
Would you say it'd be fair to say if they'd went forward their project back in, say, 1973, they'd have probably not had this issue?
Yeah, the way these projects work, the answer is yes. The CEQA started applying in 1970, and they came in just under that. So their discretionary approval for the map was in January or February 1970. So if they had applied after that, the way it would work is they'd have to have a full-blown EIR before there was an approval of their subdivision map. And then every single subsequent discretionary approval would rely on that EIR. And because we don't have that going forward, we need that EIR. Otherwise, the county can't make any discretionary approvals going forward, and all the other agencies can't make any discretionary approvals going forward.
Yeah, so previous to CEQA, if they'd have got their project going, we wouldn't have this question.
Yes, we wouldn't have this. If they had applied after 1970, this wouldn't even be an issue.
I mean, okay, yeah, correct.
Yeah, I think it's important, there's some confusion. The developer's saying because we had our approval prior to 1970, CEQA was no longer an issue for this project, period. That's just not the case.
If they'd have built it pre-CEQA.
If it was done pre-CEQA, then that would be the case. But every time a discretionary approval comes up, you gotta have that environmental document. And the problem here is that they're seeking discretionary approvals, but there's no environmental document. So they're inviting the county to blatantly violate CEQA.
And part of that discretionary approval is it has to meet those secret requirements.
Yes. You can't act on a discretionary approval until you comply with CEQA.
Okay. Mr. Johnson?
Well, that was interesting. So where to begin?
All things interesting.
Yes, it is. So I began my discussion this morning by saying we are not saying that CEQA doesn't apply to this project. I said that for every discretionary approval that we seek, now CEQA does apply. But I said CEQA cannot be used to reanalyze the entire project that has already been approved. That's an important, very important difference. So you can't use a grading permit as an opportunity to evaluate the environmental impacts of the build-out of the entire subdivision. That's what's not allowed here. And that's the important nuance that staff is not recognizing or discussing with you. What they can analyze is the scope of impacts associated with the grading permit. This idea of piecemealing is interesting. The project itself is the subdivision. The subdivision cannot be reviewed under CEQA. It's exempt. Predates CEQA, period. The only thing that can be analyzed now are discretionary permits going forward. They have to look forward. They cannot look backward. That's a critical point here. The idea that we are inviting the county to violate CEQA is laughable. That is not at all what's happening here. We are simply arguing that the county must comply with the Permit Streamlining Act, and the county must abide by its existing approval of the subdivision and confine its analysis of CEQA, its CEQA review duties, to the specific entitlements that we are requesting going forward. That's much simpler than the picture that you've just been given. The idea that there is some provision in the Permit Streamlining Act that, again, the Supreme Court said that the legislature enacted the Permit Streamlining Act to relieve applicants from protracted and unjustified governmental delays in processing their permit applications. The idea that there is a loophole in the Permit Streamlining Act wide enough to drive a bus through, as you've been told this morning, is completely false. And I'm sorry it's going to take the Third District Court of Appeals to make that clear, but apparently that's what's going to have to happen. It's just untrue. You cannot have a loophole. And the idea that there are who knows how many actual permit application requirements that Mr. Spitzer actually reviewed, that half of them have such a provision, is meaningless. There are illegal provisions in county codes and city codes all over the state. Doesn't mean that they're legal. So the question is, again, very simple this morning. Has the applicant submitted the requirements on the county's checklists to necessitate that the county deem these applications complete? You have not heard staff say that they haven't. That's important. All of the requirements on these checklists have been submitted to the county. County is now required to deem the applications complete, period. The determination as far as CEQA goes, this is another issue. You heard your county council this morning say 3 times that there's going to be an EIR for this project before they've received any of the information that they apparently need to make a CEQA determination, mind you. But that very statement itself is a pre-committal that's in violation of CEQA. You can't have staff predetermining what kind of CEQA document is required before they even have the requirement, the documents that they think that they need to make that determination. So there's a problem here. Staff is advising you, the board, to disregard the Permit Streamlining Act and to pretend that there are rights under CEQA that don't exist. So again, I request that you please deem these applications complete so we can move on to these questions in earnest. Thanks.
Mr. Johnson, I got a question for you. Have you ever lived in a home that has a septic tank?
Yes.
Okay. How big is your property?
It was 2 acres.
Okay. Part of these are half-acre properties.
Understood.
So, you know, the septic systems, leach fields go out. Should we not protect our future constituents with any?
So you're asking a technical question. I'm not here to discuss the technical specifications for leach fields and septic tanks. Can they exist on half-acre lots? Yes, they can. There are technical ways to make that happen. But again, you're asking a question about a project that's already been approved.
Understand. So you're saying to me that this project is being stale, as you admitted it's 51 years old. So are you going to use a 1973 bulldozer to bulldoze this project?
So I think that that question is facetious.
It is,
So-
but it's also, you know, that's kind of the
Yeah.
the wherewithal we're running with here.
Not really.
It is.
No, it isn't, and there's a reason why. In California, we have such a thing as real property law, and we have property rights, and those are constitutionally protected. My client has a constitutionally protected real property right in this subdivision map and tentative map as approved, period. You may not like it, I may not like it. I do these projects all over the state. I understand there's differences.
Well, I agree. You know, I hate sprinklers in new homes. You know, I live up in the high country.
Yeah.
So they freeze, then they break, and then they come out. But that's still a law that's on the books that needs to be prescribed for homes.
True. In this case, there are some things about this approval, can't change it at this point. That's the reality. This project isn't going away, gentlemen. My client, this is a 281 unit subdivision. It will be built. And if it takes years of litigation, that would be unfortunate, but that's the level of commitment here. I think the value in having dialogue with you this morning is to, I think, identify that there needs to be a better path forward, one that's more efficient with county resources, with the applicant resources. I'm not saying that there aren't areas for negotiation and compromise, but we can't pretend that the law doesn't say what it says. We can't use loopholes that don't exist, and that's the problem. Thanks.
Any more questions? Good. Any members of the public like to comment on this issue? Is there any on Zoom too also, Jennifer? Yes, please come forward, sir.
Hello, my name is Russell Parker. I know this is specifically related to the question of this particular grading permit, but the issue of the subdivision being a done deal was raised a number of times, and it seems, laughable to think that a 50-year-old approval should be considered bedrock solid. I mean, it would be very different if they'd been actively pursuing the subdivision and had been building 4 homes a year every year since then, and we're 281 in. But the fact that none of them have been built yet, I mean, there's no way that the Board of Supervisors 50 years ago could have been prescient enough to know the state of the county at the moment. But to the specifics of the grading permit, there were a couple of things. Sounds like these roads would be taken over by the county. If that's correct, then it seems completely reasonable that part of the requirements put in would be the same sorts of things that Public Works would be looking at for any road that was being built by the county itself. If the county's going to maintain them, then the soils analysis and the other things that would go into, is this a road that the county would want to take over? Seems reasonable to ask. The Permit Streamlining Act, the intent of that is to keep counties or agencies from sort of dribbling out additional things, in requirements to, to drag their feet and delay things. This does not seem in any way like what's being done here. Part of the application complete process, if one thinks of it conceptually, is an agreement from the agency saying, if you give us these sets of things, that will give us enough information to be able to make a decision, a thumbs up or thumbs down on this. So it's actually to the benefit of the applicant to give them everything that they're asking for. It's, since if there is information missing, what these additional requests are saying is, in order to be able to go forward with an approval of this, we will need these additional things. So if they were to say application complete without those, that's disingenuous, because they will need that to make a good, to make that approval decision. The other final aspect on this, well, two, I found it somewhat offensive to hear what I thought was essentially a threat to the Board of Supervisors, saying this project is going forward. If someone was bringing a new project forward and were to tell the Board of Supervisors that would seem insane. But the final thing is, if this is approved and goes forward, I think it would be good for the board to put some kind of a provision in, since I don't think it is a given that this 50-plus-year-old approval on the subdivision means that all 281 homes are going to necessarily be built, that if they do go forward and spend the investment to do all this grading and everything else, that cannot be used as support for, well, we've made all this investment, you need to now allow us to build the homes. That if that subdivision is not, at the end of the day, approved to go forward for any of a host of reasons, that there is no recovery if this particular piece is allowed and they put money into doing this grading and the like, they're saying this project will go forward, but if it doesn't, they don't get to ask for recovery of those monies from the county. Thank you.
Thank you.
Good morning, Supervisors. Craig Baracco, Foothill Conservancy. Just wanted to say a brief word of support for the denial of this appeal and uphold the county's position. There's a long-established principles of CEQA is that approval of infrastructure such as roads and sewers that will result in future development needs to be accounted for in the CEQA process. This is not an isolated country road that may or may not result in homes someday. This is a road network for a subdivision that will clearly result in hundreds of new homes that will require water, sewer, and the rest of the items, all of which are, in fact, CEQA checklist items. We need to know how those services are going to be provided. You can look at the existing parts of the Comanche Village that have been developed and have had real, genuine issues with sewer and wastewater and all those associated issues. You guys have a tax sale coming up, and as usual, there's a bunch of Comanche parcels that are on the line, going to be abandoned basically by their owners to tax sale because they're undevelopable. And these lots sort of get handed around by various people, but essentially there's not adequate infrastructure for those. This is a portion of the county that's in the Central Valley groundwater system, and that's a hugely impacted groundwater system with way too many straws and the like. This all needs to be considered, and to think that we can just approve roads without accounting for the inevitable homes that are coming with them just isn't, I think, a valid way for us to do business. Regardless of how it turns out, what decisions this board will make, what the details of the environmental document will be, it's incredibly bad precedent just to allow an applicant to say that they won't submit necessary information for a CEQA analysis. And I urge the board not to set that bad precedent. So, thank you for your time.
Thank you.
Thank you. Looks like no Zoom, Jennifer? Any person that hasn't spoke like to speak in this matter? Mr. Parker, you can have a second bite at the apple.
This is just a very quick one. I think it would be in the interest of the developer to look at the current situation in Ione. The AWA recently had to put a emergency injunction in on doing new connections. Those included developments that had existing will serve letters and things that I think are actually likely much more recent than 1986. So that's currently preventing any new building, any new connections in the Ione area, without specific approval by the AWA board. So even if everything else was done at this point in time, just having a will serve letter doesn't necessarily mean that you're going to get water. So they might want to take a look at the situation in Ione before presuming that everything they might possibly want is going to be there when they're ready to go forward, should it be allowed to go forward. Thank you.
I think one thing I see, the question here is not whether the subdivisor has entitlements to subdivide from the county. I think they do. But the question is, does CEQA apply this project as you move forward? That's really the question I see, and it appears that it does. We might have some people may still want to talk. So we'll at some point we will. That's kind of one of the questions I see really, and I would think if the county said, "Hey, we believe that it's not required, or you can go forward," I think it'd probably cause a whole lot of problems. I think it'd probably be wrong. It'd cause developer issues. I think it'd cause the county issues. Because it appears like some of these things do trigger CEQA. Like you're talking 58,000 yards, that's a lot of dirt. Even on a 281 unit subdivision, you're talking, that's a pretty significant effect.
Glenn, could I ask you a question on that too? It's 50-some thousand yards of dirt, and they're applying for a finished grading permit? They had a permit, it expired. That was a rough grading permit, is that correct?
You know, Mark, I don't know if you have more to add about the specifics.
Or whoever, yeah.
But this particular grading permit is to move 58,000, I think 750 cubic yards of dirt.
And the county ordinance says over 5,000, you need a special permit.
When you exceed 5,000, you automatically trigger CEQA, is what the county says.
Automatically.
Yes.
But their contention is that we can only look at the CEQA for the grading permit. But then we're back to the piecemeal argument, and you put dirt over on this property, and then it changes the water courses and all that other stuff. I'm just guessing, but you can't look at it like it's in a bottle.
I think that what you're saying hits the nail on the head. More than anything, this is a piecemealing issue. They're saying ignore everything else. Ignore that homes will actually be built here. Ignore that people will live here and will use water. Ignore that people will need sewers. So yeah, I think that that's exactly correct, is that they're looking at it in a very myopic way.
Well, at this time, I think we'll close the public hearing.
I move for a motion. Close public hearing.
Second.
We got a motion there, second by Brown. All in favor?
Aye.
Aye.
Aye. Any opposed? Carries unanimous. Well, any more questions from the board, or just thinking about it? And you know, too, if, I don't know if we will, but if necessary, we could continue this, correct, Glenn? Yeah. If the board wanted to think on it. Okay.
Well, I'll make a motion to deny the appeal.
I'll second it, but I'd like to ask for some additional language to be included in the motion.
Okay.
And this is straight out of the demur, but the PSA and CEQA do require agencies to request information, or allow agencies to request information necessary to perform environmental analysis. And the county's checklist does state that the county may request additional information as needed.
Okay, that's part of your motion then, Frank?
Yes.
Okay. And I think you second that, didn't you, Richard?
Yeah. Yes.
Okay. All in favor this would be to deny the appeal?
Aye.
Aye.
Aye. Any opposed? That carries unanimous. The appeal is denied. And I think that is it. So the board is adjourned, and we'll reconvene back. Let's see what the date here is, on Tuesday, March 12th, 2024 at 9:00 a.m. Thank you.
Is that we're upstairs at that time?
Pardon?